Prasad for his contribution to the debate. Honorable members, that ends that agenda item, and we will move on. Secretary General.
Consideration of bills.
I now call upon the Attorney General and Minister for Economy, Civil Service, Communications, Housing and Community Development, the Honorable Ayaz Syed Qayyum, to move his motion. You have the floor.
Thank you, Mr. Speaker, sir. Mr. Speaker, sir, pursuant to Standing Order 51, I move that A, the Electoral Registration of Voters Amendment Bill 2021 be considered by Parliament without delay, that the bill must pass through one stage at a single sitting of Parliament, that the bill must not be referred to a standing committee or other committee of Parliament, and that the bill must be debated and voted upon by Parliament on Wednesday, 22nd September 2021, but that 1 hour be given to debate the bill, with the right of reply given to me as a member moving this motion. Thank you, sir.
Is there a seconder?
Honourable Speaker, sir, I beg to second the motion.
I now call on the Honourable Attorney General to speak on his motion. You have the floor.
Mr. Speaker, sir, I intend to be brief, but essentially, Mr. Speaker, sir, this particular amendment seeks to ensure that the constitutional provisions of requiring ensuring that we have a registered voter actually voting in the elections, and that there be equality of votes between every single voter is in fact put in place in practical terms. That's what I would like to say at this point in time, sir, given this on motion 51, and that we debate this particular amendment on Wednesday, sir. Thank you.
Honourable members, the floor is now open for debate on this motion. At the end of the debate, we will have a right of reply from the movement. Anyone wishing to take the floor? Honourable Kanawai Kula, you have the floor.
Thank you, Honourable Speaker. We are objecting to the motion. The motion is being tabled under Standing Order 51. And every time government tables an order under a motion under Standing Order 51, it is asking that the scrutiny or participation of the public in the lawmaking process is to be denied. And that's what we are asking here. And this is not a simple amendment. Honourable Speaker, this amendment goes back to the litigation that we have against me personally. And it is to amend the electoral registration of voters. We all know what happened. What happened in that case is that the decision was made by the Chief Justice that the supervisor of election acted unlawfully and wrongly. Period. That is how he interpreted the law. And we should respect the independence of the powers. We should respect the decision. This is another way of appealing that decision. This is another way of appealing that decision. In the court process, when you are not happy with the decision, you appeal it. They cannot appeal it. They cannot appeal it. They should respect it. They should respect the integrity of the decision, because it's not the Chief Justice, Honourable Speaker. The Chief Justice only interprets the law. They are the ones who made the law. They are the ones who passed the latest amendment in June. And that was tested in the judgment. And they were found wanting. They should respect that. And I think the Honourable Minister, the Honourable Attorney General is lying when he says this is to put into effect the constitutional provision for fair voting. Voting has been fair all this time. And if that is the case, why didn't you make this amendment much earlier on? All that the Chief Justice said is that if you don't have to be using your name in the birth certificate for any election to be fair. And that is common law. It is done here, it is done in Australia, it is done in New Zealand, it is done in the UK. So it is wrong. And the government must be honest in its intention to say that it's not happy with the decision of the Chief Justice. That is what they are doing. This is a criticism against the judiciary. This is a criticism against a body that you're not allowed to do. And they are trying to do it in a backdoor kind of way. So, coming back to the procedure, Honorable Speaker, it is important. It has a public importance. It needs to go through the public, which means that it has to go through the proper parliamentary committee process so that politicians, NFP, members of the public can come in and put their views. It's so important. We don't have the mandate to decide this by ourselves. It has to be out in the open. It is a political thing. It deals with the public on the registration of voters. Their voices should be heard. And that is the reason why we are opposing this motion coming into Standing Order 51. Thank you.
Thank you. I thank the Honourable Waikula for his contribution. Honourable Linda Tamuea, you have the floor.
Thank you, Honourable Speaker. I rise to also oppose the motion before the House and add to what my colleague, Honourable Waikula, has already contributed. This particular proposed amendment, Honourable Speaker, really, at the end of the day, can affect a very huge number of our population, which are married women who use their husbands' names and have been using that in their voter registration and to vote in the last two elections. Honourable Speaker, this is being rushed. It should go back for consultation, Honourable Speaker. This should be taken out to the public to consult and to give their views on this. Not only are they taking away the right of a married woman to use her married name to register and to vote, which is what she's been using in the form of her ID, in all other IDs, it will also cost those that need to change. It will cost those that need to change their names if they choose not to use their name on the birth certificate, Honourable Speaker. They have to go through a deed poll change, a legal change in their names in order to use their married name. And Honourable Speaker, that costs money. Yeah, you have to go to a lawyer and have almost up to $500 to pay for a deed poll change. And this is what this government is not considering when they're bringing about this change. This, Honourable Speaker, will just continue to discriminate our voters, so it makes it harder to vote next year, especially our women in the rural areas. What is the access from the supervisor of elections? What's the access for our women in the rural areas to ensure that they are informed of this? You need to consult and get their views on this. But they're not doing this, Honourable Speaker. They're trying to bring this into the House once again, rushed under Standing Order 51, Honourable Speaker, and that's why we oppose this motion before the House. The Standing Committee should take it out for consultation and get the views from those who are mostly affected. And they will be, Honourable Speaker, a very big portion of our population, which are our married women. Thank you, Honourable Speaker.
Order. I give the floor to the Honourable Lavangavoka. You have the floor.
Thank you, Honourable Speaker. I agree with my colleagues that this is a very important bill, and it needs to be taken through the normal process of law making. Standing Order 51 is being overdone. Just last week, we celebrated Democracy Day, and I noticed from your statement, Honourable Speaker, that this Parliament has passed some 274 laws. 274 laws, Honourable Speaker, the vast majority came through this way. And somebody had characterized the way we do business here as legislation by ambush. We arrive on Monday like this, not knowing that this bill was coming into the House, and we debate the pathway now, and it becomes law on Wednesday. This is legislation by ambush. We cannot say that we are proud of our parliament. We have passed 274 laws, and the vast majority came by way of ambush. At least, let's turn our back to the celebration for democracy last week and set a new pathway for how we make laws in this parliament. Can you imagine that? In 7 years, we have passed 274 laws. All through ambush. All through ambush. In jurisdictions overseas, you have at least 2 months. 2 months notice that a bill is coming. And then you go into the first reading, the second reading, and the third reading. Over here, we should be ashamed of ourselves that we are making laws in this manner in this country. So, Honorable Speaker, we hope that we can change the way we do things. Let's not say 274 laws and be proud of it, because really, we should be ashamed of the way we make legislation in this country. Honorable Speaker, this is very, very important, and there is already chatter in the community on what will happen to married women. What will they do now? So there could have been some dialogue on this. This is a huge issue, Honorable Speaker, and we have to change. We cannot be proud of the way we are doing things, and we should stop this legislation of ambush in this House, Honorable Speaker. Thank you.
I thank the Honourable Member for his contribution to debate. Honourable Professor Biman Prasad.
Thank you, Mr. Speaker. The genesis of this bill, in my view, is really to correct the incompetence of certain constitutional office holders who rushed into getting rid of Honorable Nwaikula out of the House. And of course, the judiciary, had other views, and he's back in the House. Now let me say this also, Mr. Speaker, and I think Honorable Gavoka is right. This is lawmaking by ambush, and he quoted lawyer Richard Naidu. But, this is a government, Mr. Speaker, this is a government which governs through ambush. Not only lawmaking, if you look at the behavior, in policy, in lawmaking, it's all about we can rush through, we can trample over, we can, continue to do what we want to do. That's fine, Mr. Speaker, but let me say this. Of course, governments respond to what the judiciary says about certain constitutional provisions, certain laws, and there is always a need to come back to Parliament to change certain laws. No, that's understandable, Mr. Speaker, but in this particular case, there are a lot of implications. I mean, the supervisor of elections has already got the provisional rollout. I'm not sure how many people will need to go and re-register, provide all this. These are questions that we need to take time and consider and let people make the submissions. So, rushing this bill, in fact, I would say that, we should leave the changes to some of the electoral laws and all that until after the election. It's too close to the election to be changing these laws. And Mr. Speaker, let me remind Honourable Attorney General. Let me remind Honourable Attorney General. I know he knows, that's why he's laughing. The whole genesis of the electoral law, political parties law, they were all done not by the Parliament, not by an elected legislature. It was done by the interim government. And, Mr. Speaker, laws kept changing. Laws kept changing right up to the day before the election in 2014. And then after 2014, Mr. Speaker, they continued to change the laws because every time they were shown the faults in the law, So instead of going back to the people and having a much more considered view about, what the changes should be, they are rushing it again. They are rushing it again. I mean, we have accepted Order 51 on many occasions, Mr. Speaker, because we have understood that there was an agency. And we participated in it, and we also voted for some of the legislations, the bills that they brought into Parliament. So it's not as if we stand here, in the opposition, ready to oppose anything that comes from the government. We don't. We have in the past, supported government bills on important matters. But this one, Mr. Speaker, they need to take it back. They need to leave it until after the election next year. Because this is going to create unnecessary confusion, unnecessary requirement for people to go back and re-register or provide all this. Unnecessary. So, please, take this back and leave it until after the next election. Thank you, Mr. Speaker.
I thank the Honourable Payman Prasad for his contribution. I give the floor to the Honourable John Samate. You have the floor.
Mr. Speaker, I'll just defer to the right of reply from the AG.
Any further members wishing to take the floor? There being none, I give the floor to the Honourable Attorney General for his right of reply.
Thank you, Mr. Speaker, sir. It's very entertaining listening to the other side, sir. In usual capricious manner, you have Honourable Nawai Kula, Honourable Tambuya jumping the gun, Honourable Niko Nawai Kula and Honourable Tanya Wanganiika and Tambuya need to also know, they are the three lawyers on the other side, that laws are actually made by Parliament. Courts make certain decisions, they interpret the law, and it is not something peculiar to this government. Since the history of lawmaking in the common law countries, when courts interpret particular matters, particular laws, if the Parliament, the legislature believes that there needs to be able to be a reason to address any lacuna in the law, any shortcomings in the law, or the law actually may be out of date, the legislature actually makes those changes. There are many laws, Mr. Speaker, sir. Some might call it very trite provisions. Honourable Kepa, I remember specifically talking about this. We used to have a Workmen's Compensation Act. It was acceptable for decades, in fact a century. Now we've changed to the Workers' Compensation Act because it's not only men who work. There are many laws like this that have been amended. The previous Companies Act that was repealed when we brought in the new Companies Act had been amended literally dozens and dozens and dozens and dozens of times since its inception, post-independence. Does that in any way mean incompetence of those governments? Times change, technology changes. In this particular case, it was the Court of Disputed Returns. And the Court of Disputed Returns, given the law, given the submissions that we are on record on saying was not actually full submissions made to the court, and the Court of Disputed Returns, as we all know, Mr. Speaker, sir, does not have the luxury of accepting common law principles of adopting common names. These common law principles, Mr. Speaker, sir, in many jurisdictions came from the last century. AKA, also known as. Since then, Mr. Speaker, sir, we are living in the 21st century. There's identity theft, there's money laundering, human trafficking, terrorism. All countries, Mr. Speaker, the voter ID to ensure that we have authentication of your identification. Critically important. And here we are getting a smorgasbord of opinions for political reasons. Mr. Speaker, sir. Mr. Speaker, sir.
Order.
The reality of the matter is that Honorable Tambuya again jumped the gun, brought in women's issues. But she forgets to look at the various amendments we've made. She has not read it in full. This is why, Mr. Speaker, sir, in the introduction of this, I refrained from going into the details of it. Because I thought the opposition, who will have 3 hours to look at these 3 bills, will be able to study the bills, come back to us on Wednesday, and perhaps make more intelligent comments. But they have failed to do so. She said married women should have the right to use their husband's name. Of course, the law does not stop that. In fact, Mr. Speaker, sir, in fact, we've given women the option. If she looks at the amendments under the BDM Act, Mr. Speaker, sir, registration, if you look at the existing law, it says only the father of the child can register the son or daughter. Only the father. We made an amendment that should be the mother or father. Mother or father. We have also said, she went on about the deed poll, she should read the amendment. She should read the amendment. We've removed the requirement of getting a deed poll done. No longer, have to go to expensive lawyers to get a deed poll done. You simply go to the birth registration office. If so, for example, a woman who's married now and decides to adopt her husband's name, all she simply has to do is go to the BRN office. I want to change my name. They'll register it. Birth certificate will be given. Very simple.
Order.
Mr. Speaker, sir. You see, you're caught out. Mr. Speaker, sir, she has the option. If you married a Mr. Prasad, you want to become Mrs. Prasad, your choice. You want to retain your name as Tambuya, you can retain your name as Tambuya. Your choice. Nobody's forcing you. And now, you don't have to do a deed poll. You simply just go to the BDM office. We have dozens now throughout the country where you can go and register your new name should you wish to do so. And the point, Mr. Speaker, sir, I don't know what you're on about. The point is, Mr. Speaker, sir. The point is, Mr. Speaker, sir, the existing law at the moment is that there are a lot of irregularities. So because there is no opportunity to do that, there are many women, when they get married, under the current regulations, if they want a passport, they can go to the passport office and they'll say, this is my birth certificate, this is my marriage certificate, I want my passport to be under Mrs. Kappa. They can do that. That was the previous way of doing it. But Mrs. Kappa won't be captured in the BDM. Currently, when somebody dies and the police have to issue a death certificate, they don't go by the name that somebody gives them. They have to look at the birth certificate name to give a death certificate. All we are simply trying to do, Mr. Speaker, sir, is to ensure that we have the right name for the right person. And that name, Mr. Speaker, sir, is known throughout all your official records. If in the meantime, Honorable Tambuya wants to change her name to Miss Linda Prasad, right? She has the opportunity to go and do that. She can simply go, no deed poll, simply go and register at BDM, and now as provided under the amendment, the BDM registrar is compelled to inform all the other agencies that we had a Linda Tambuya, Honorable Linda Tambuya who came in, she's now going to be Honorable Linda Prasad. If, however, Honorable Linda Prasad, 5 years later, for example, wants to become Honorable Linda Maharaj, she can become Honorable Linda Maharaj, she can go and change her name. We've also allowed under the law that if a husband wants to adopt the name of her wife, of his wife. They can do that. Some people do that. They can do that. So all of these are there. Absolutely. There's an opportunity there. But of course there'll become another drama. But Mr. Speaker, sir, so all the amendments are here. Sorry? Well, there's an opportunity, as I said. So, Mr. Speaker, sir, it is not challenging the court's decision. The court said, as the law was drafted, and unfortunately the council did not bring to the attention of what would happen, that you don't, literal interpretation, have to have the birth certificate. No chaos will be created, Honourable Prasad, because if you look at the electoral card, now they always are updating it. It never expires. And the Supervisor of Elections is on record issuing a very lengthy and comprehensive statement which your newspaper, Fiji Times, did not publish until 5 days later. In that, Mr. Speaker, sir, he quite comprehensively said that when we issue a new card, you need to then register under your BRN. You have to do that. If, however, somehow the other you fail to do that, that registered name will continue on the voter list. Last point I'd like to make, Mr. Speaker, sir, for them to also ponder upon. Somebody, one of their esteemed lawyer colleagues said, oh, if a person registers 3 times, we'll know that they're voting 3 times because they'll have the ink on the finger. We've seen in so many jurisdictions, Mr. Speaker, sir, I can go and register under 4 different names, and then I can ask for postal ballot for 3 of my names. Nobody inks you. You make a simple application to the Supervisor of Elections. You say, my name is in the voter list, Ram Dulare, I want to vote because that day I'm driving my bus or whatever. He does not go and check whether you're driving a bus on that day or not. They simply take your word for it. I can be under Ram Dulare, I can be under Honorable Tambuya, or whatever it is. I have different names. And then I get my postal ballot and I'll vote. I'll send my votes. On the day itself, I can go and vote under my actual name and get the ink. Honorable Gavoka always talks about, oh, this government has got only, won by 100 votes or 1,000 votes, whatever he says. We know that elections have turned in some of the constituencies on 10 votes, on 12 votes. If the shoe was on the other foot, if they're saying don't do it until the next elections, it's also to protect you. What if some of Fiji First supporters go and register 5 times each? And then you lose the elections by 500 votes. You'll come complaining, you'll say, oh, this voter list has got no integrity. See, don't think politically. Think from a system process perspective and integrity of the electoral roll. The voter list must have integrity. And therefore, we must reduce and eliminate any opportunity for ambiguity. That's the rationale behind this. Thank you, sir.
I thank the Honourable Attorney General for his right of reply. Honourable members, the Parliament will now vote. The question is, pursuant to Standing Orders 51A, that the Electoral Registration of Voters Amendment Bill 2021 be considered by Parliament without delay. B, that the bill must pass through one stage at a single sitting of Parliament. C, that the bill must not be referred to a standing committee or other committee of Parliament. And D, that the bill must be debated and voted upon by Parliament on Wednesday, 22nd September 2021. But that 1 hour be given to debate the bill, with the right of reply given to the Honourable Attorney General as the member moving this motion. Does any member oppose the motion? Yes. There being opposition, the Parliament will vote by acclamation. Those in favour say aye. Aye. Those who oppose say nay. Nay.
Nay.
Nay.
The ayes have it. Honourable members, at this point, we will suspend proceedings for a break for lunch